Right away, this case opens with a serious felony drug charge. Possession of even a small amount in this penalty group can carry up to 10 years in prison, which surprises a lot of people. Do you think most defendants realize how severe drug possession penalties can actually be?
2022 CR 3997, State of Texas versus Vanessa Vega. Can I have parties announced for the record for the state?
Ryan Grimmer for the state of Texas.
John Robertson for Ms. Vega.
And are you Ms. Vega? All right, I'm going to need you to speak up so the court reporter can hear. Defense, I'm showing you the acknowledgement of discovery. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Vega, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes.
Next, I'm going to show you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
We're not, Judge. At this time, the state would make an oral motion to proceed on the lesser included offense of possession of a controlled substance 1 to 4 grams.
No objection.
All right, Ms. Vega, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of possession of a controlled substance penalty group 1 to 4 grams? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
This is a massive legal turning point. The judge is explaining that by accepting a plea deal, Vanessa is giving up her constitutional rights, including the right to a jury trial. Plea bargains often speed up cases, but they also place enormous trust in the court's final decision. Would you risk giving up a jury trial to avoid a harsher sentence?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you to 10 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the
I
offense?
believe she is.
Ms. Vega, has anyone threatened you, coerced you, or placed you in fear to get you into this plea?
No.
Has anyone promised you anything other than the plea bargaining agreement?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state's plea proceeded on the less included offense, possession of controlled substance penalty group 1 to 4 grams. Punishment to be assessed at 4 years in the prison. There's an X by the fine, but nothing written on the fine.
Also, Judge, I think they
The 4 should be at the bottom.
correct.
All right, thank you. Do you want some whiteouts?
Actually, Judge, that would be awesome. Thanks.
Yes.
All right, so I'm going to show you the plea bargain page again. Did you review that with your attorney? Did you understand it?
Here's where the deal becomes clear. Deferred adjudication. This is basically a legal second chance. If Vanessa completes probation successfully, she could avoid a permanent felony conviction. But if she violates even one condition, the judge can sentence her to prison immediately. It's freedom, but with a ticking clock attached.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motion?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is recommending that your deferred adjudication be for a term of 4 years. There'll be a TAP evaluation, 120 hours community service restitution, and restitution to SAPD for drug testing. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense of possession of a controlled substance penalty group 1 to 4 grams. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge. State would offer State's Exhibit number 1 and all attachments.
No objection.
Ms. Vega, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports and laboratory reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I've asked the court to follow the plea agreement. Vanessa is getting her life in order, and I think she'll do well on deferred, so we ask you to give her that opportunity.
All right, and off the record, I believe you informed the court that there was some pending CPS matter.
That's kind of resolved right now, Judge. I talked to the CPS officer on Friday, and this weekend Vanessa signed temporary custody of her kids, and she's going to be working with them they were going to defer to probation as far as programs and everything like that goes, but that's going to get worked out eventually.
All right, and is that here in San Antonio?
It's,
Okay. Have you been given a copy of the service plan
I think
for
that's-
CPS? Did
that's
they
still
give you
in
a
the
service
works.
plan? And who is your attorney? In
Think you have a
CPS.
CPS attorney yet?
Okay, that's odd, but you wouldn't have a CPS.
I don't know
attorney.
that, I don't know, there was,
Was this a motion to participate?
no, I think it was all kind of informal. Is that accurate?
All right, did you actually go inside a courtroom? Okay, you're gonna need to say yes or no.
No, I didn't go into a courtroom.
All right. How many children do you have?
2,
What are their ages?
14 and 6.
And are they with your mom?
They're with a family friend.
Why are they not with family?
I don't have any family.
Okay. Are you product of CPS?
No,
Okay, where is your family?
they died.
So you don't have a single living relative.
I don't talk to them. I don't talk to them in my family.
All right, if you drug tested,
This moment is extremely revealing. When the judge asks about drug test results and Vanessa admits she'll test positive, it dramatically raises the stakes. Judges rarely hear defendants openly admit ongoing drug use during sentencing. Do you think honesty helps her credibility or hurts her chances of leniency?
okay. Sometimes when our families are estranged for us, sometimes it's their fault, but sometimes it's our fault. And sometimes you have families who are doing tough love. They're like, can't help you anymore. We've done all we can do. You understand?
Yes,
All right. So who are you living with?
I live alone. I have a home. Like I rent a home.
Okay. All right. Are you employed?
Not currently.
So how are you supporting yourself?
I just lost my job, so I'm looking for employment.
Okay. Did you lose your job or did you quit?
I got fired.
Okay. And what type of job are you seeking?
Like sales, customer service.
Okay. All right. This is what
Now the judge delivers one of the most structured probation plans you'll ever see. Drug court referral, parenting classes, weekly monitoring, employment requirements. This isn't just punishment. It's a court-designed rehabilitation program. The real question is, can strict supervision actually break addiction cycles? Or does it sometimes set defendants up to fail?
Yes, ma'am.
I'm going to want weekly reporting by Zoom or in person until accepted in felony drug court. I'm going to want a TAP evaluation just in case felony drug court, maybe they're full, but otherwise they should accept you. There should be no unsupervised contact with minors. There should be CPS compliance. So I'm going to tell you right now, I've done CPS cases before. And if you and your friend are planning on doing this thing where on paper she has children, but in reality you have the children, CPS is ultimately going to find out, and when they find out, you're going to have a legal case. And what that means is your children are going to be under the umbrella of CPS, and then your friend is not going to be allowed probably as someone to be considered for placement. And since you're saying you have no family, that would mean that your children would be in foster care. Do you understand?
I mean, I went on.
That's either yes or no.
I do understand, yes.
All
ma'am.
right. There's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's restitution to SAPD for drug testing. Probation, is there anything else that she needs?
Is there an amount for the restitution, Your Honor?
No.
No, Your Honor.
All right, is there anything else you need from the court in order to be successful?
No, ma'am.
All right, and I'm going to ask that the warrant be recalled. I'm going to show you what's entitled Trial Court Certification of and Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record.
The judge's closing speech shifts from legal authority to personal life advice, which is something viewers often don't expect in criminal court. She warns Vanessa about relationships, addiction triggers, and parenting responsibility. Moments like this show how judges sometimes act as both authority figures and life counselors. Do you think this type of tough honesty helps defendants rebuild their lives?
Good luck to you, okay? All right, the court is calling 2022 CR 8095, State of Texas versus Miguel Ocampo. Could I have parties announced for the record for the state,
Joe Hooker for the state judge.
for the defense? And are you Mr. Ocampo?
Yes, ma'am.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Ocampo, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Ocampo, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Okay, I'm gonna need you to speak up, okay?
Yes, I did.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe him.
Mr. Ocampo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 18 months in the state jail facility. There are no applications. There's to be restitution of $22,000 to Ruben Aguero, Aguero, and restitution, if any, for damage to truck belonging to Tommy, Tommy, Bui, Bui. Did you understand that to be the plea bargain agreement? Defense, is that the plea bargain agreement?
Yes, it is.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions? Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge, the state presents State's Exhibit 1 and attachments.
No objection.
Mr. Ocampo, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're asking the court to accept the plea bargains and put that with the state.
All right, the court will follow your agreement, sentence you to 18 months in the state jail facility. There's to be restitution of $22,000 to Ruben Agar, and restitution, if any, for damages to Tommy Boy's truck. We'll give you credit for any time served. Is there anything else from either side with regards to sentencing?
Nothing from the state, Judge.
Nothing from the state.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand? If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. We can go off the record. Here's the thing. If you want a vehicle, you got to earn it. Don't take what does not belong to you. Do you understand? All right, good luck to you.
Thank you, Judge.
You're welcome. Good seeing you.
The case of State versus Vanessa Vega begins routinely, with the defendant applying for deferred adjudication on a possession charge. Prosecutor Ryan Grimmer reduces the offense, setting the stage for a potential probation deal. But the true gravity of the situation is unleashed by Judge Stephanie Boyd. At 2 hours, 10 minutes, and 12 seconds, she delivers the punishment warning that defines the entire hearing. By pleading, Vega is admitting to a crime that carries a potential sentence of 2 to 10 years in prison and a $10,000 fine. Judge Boyd meticulously ensures Vega understands she is waiving her constitutional rights for this bargain. The real destruction, however, comes not in a sentence of prison, but in the terrifying conditions of her freedom. After accepting Vega's no contest plea and deferring a guilt finding, Judge Boyd pivots to the underlying issues. She directly references Vega's pending Child Protective Services case, directly connecting her drug use to her fitness as a parent. In a masterclass of authoritative oversight, Judge Boyd structures a probation term designed to dismantle the defendant's destructive patterns. She imposes a 4-year deferred adjudication, a probated $500 fine, and a staggering 120 hours of community service. But the true weight comes with the special conditions: mandatory parenting classes, a UA hotline for random drug testing, a referral to intensive felony drug court,
weekly reporting to probation, full compliance with CPS, proof of employment within 30 days, and even restitution to the police department for drug lab fees. Judge Boyd makes it devastatingly clear this is a plea bargain the court is following, stripping Vega of the automatic right to appeal. Every condition is a landmine. Violating any one could lead Judge Boyd to destroy the deal and impose the full decade in prison she so clearly warned about. This is a story of a judge using the power of deferred adjudication not as a simple slap on the wrist, but as a rigid, demanding framework for last-chance rehabilitation, where the threat of total ruin is the constant motivator.